on the 16th day of March 2026, I received 2 letters. One from the solicitors of Senator David Mark's group, requesting me to maintain the status quo at the Federal High Court and not to recognize the other camp led by Nafiu Bala. And on that same day, I also received another letter from Summit Chambers, the solicitors to Nafiu Bala, that by order of the court, he was supposed to be recognized as the leader, national leader of ADC. I requesting that I should comply with the order. So naturally, when you receive such communications, you have to refer it for advice. I call a meeting of the legal department and the EPM, and we look at the facts based on the judgment. And the EPM specifically requested that since there was going to be a meeting of the political parties, what do we do in this circumstance? And secondly, that they had received notice of the meeting of INEC of ADC by David Mark's group. So looking on the face of the judgment, and then I felt, okay, what you should do in the circumstance, we are just receiving this case. Invite them. Go ahead, invite them, monitor whatever. As soon as I did that, I got another letter from Summit Chambers on the 27th day of March 2026. And that letter specifically drew my attention to another motion ex parte, an emotional notice filed on the 15th day of December 2025. Now, in that ex parte application, they were asking for an order restraining David Mark and his group from parading themselves as the leaders of the party. And secondly, restraining INEC from monitoring any of the meetings or recognizing whatever that comes out of the meeting. So this was a proceeding that was filed on the 15th day of December before the judgment of the Court of Appeal. And so they were alleging that, given the fact that they had already brought the notice of the Court of Appeal judgment to me, I still proceeded to ask that EPM should monitor their next meeting, that I was in violation of that judgment. And also for inviting them for the meeting of the political parties was also a violation of the judgment of the Court of Appeal. At that stage, I now had to call for the file so that to be abreast of the fact fully, and then went through the judgment and also look at it, the order, the nature of the order granted by the Court of Appeal. Now, first and foremost, the Court of Appeal stated clearly and ordered that status quo antebellum must be maintained.
Which is a problem.
Which is, well,
because at the press conference,
yes,
Senator David Mark said that you took sides because it was not for you or INEC to interpret what status quo antebellum means, that you should have gone to the Court of Appeal to seek an interpretation instead of imposing an interpretation, because, as he said, that Nafiu Gumbe has no local standing in the matter, having resigned from the party on the 18th of May, which was communicated to INEC, and which was a letter INEC acknowledged. And on the basis of that, he was saying that, look, INEC has become a threat to democracy. In fact, the spokesperson of the party, Malam Bolaji Abdullah, in fact, went further on the morning show earlier to say that INEC has become a criminal organization, and they will not agree.
Well, that is unfortunate if INEC is being described in that form.
I'm quoting him.
But the truth of the matter is that after the Court of Appeal judgment, I received another letter from David Mark's group informing us of the rescheduling of the election activities for the primaries. And now, when I look at the motion that was already pending before the Federal High Court, that INEC should not monitor any meeting, Congress, or convention. So if you go back to the order of the Court of Appeal, and that was the major concern, if you go back to the order, none of the parties should do anything that will foist a situation of fait accompli on the court. So it means that so long as that motion is pending, if you say somebody does not have local standard, it's already gone to the court. So you have to wait. You can't just assume. You have to wait for the court to decide whether and that is part of what the Court of Appeal was saying. Let the court decide the rights and the responsibilities of the parties. So when they gave that notice to go ahead with the Congress and convention, I said that will be breaching that part of the order of the Court of Appeal that says none of the parties should do anything that will foist a fait accompli on the trial court in respect of the subject matter. And that is part of the relief they are claiming in their originating motion summons. And that is also what they are claiming in their motion ex parte and the interlocutory motion, notice or a motion on notice. So given the fact that they are informing me that they are going to hold their Congress, I think on the 9th of April.
Yes.
And the Court of Appeal said, don't do anything that will affect the subject matter of the pending case in the Federal High Court until it is decided. Now, at that stage, we felt it would be necessary to look at the complaint of all the parties. The letter written by the council, and then the letter written by them calling for us resettling their Congress. So it was at that stage that we decided to meet and look at the facts, the circumstances, what is status quo antebellum. So if they are saying that we've taken side, that is not true. Because if you look at status quo antebellum, we try to interrogate it. And it naturally means that the status before the hostility started. And in some cases, there are several authorities that says the status before the war. And the status when things were peaceful, the peaceful conduct until the controversy came. So if you look at it from that perspective, and there are Supreme Court decisions to that effect, that when status quo is even different from status quo antebellum. So when you talk of status quo antebellum, it means I have to go back. And that was the specific order of the Court of Appeal.
Prof, there is an indication of time here.
Yes.
When you say status quo antebellum.
Yes.
At what point will you put the date of that status quo? Will it be before the resignation of Nafi Bala Gombe from his position, deputy national chairman? Or will it be from the point at which Ralph Ukem-Wosu ratified the National Working Executive Committee led by Senator David Mark?
Okay, the issue of the resignation, the validity of it or not, is pending before the Federal High Court. So the Federal High Court has to make a pronouncement. That is why you cannot really say, I know, I have the record. We have record of a letter written by ADC some time ago, I think last year, informing the commission that Nafi Bala had resigned.
That was in August.
That was in August, thank you. Then the Nafi Rabiu also wrote and is contending before the court that he did not resign. And as a matter of fact, that his signature was forged. So this is a matter the court has to decide. So it's not a matter anybody can act on now. And that was why we were very careful when his lawyer was insisting that given the fact that he did not resign, and by virtue of the provisions of the Constitution of ADC, as the Deputy National Vice Chairman, when all the other members resign, of the ESCO resign, that naturally he ought to be the National Chairman of ADC. But looking at the fact that it's a matter the court has to decide, we decided that we're not going to touch that part. And then looking at status quo antebellum, given the meaning, the definition of given to it by Supreme Court, that it means before hostility, when things were still peaceful and there was cordiality until the controversy. So if you look at it backwards now, you look at it from the viewpoint of when was there a controversy. Controversy started when on the 29th day of July 2025, there was a meeting of INEC, which now ratified the appointment of David Marks Group. So that is why you had issues. So if you look at antebellum, meaning that before that time, what was the position? Now, in this case, the plaintiff went to court on the 2nd of September, 2025. He filed their motions, motion ex parte, motion on notice for injunction, and also filed further motions ex parte on the 15th of December and motion on notice, restraining us and even stopping them from parading themselves. Those are proceeding. Court of Appeal said, don't do anything that will render any proceeding, whether it is valid, whether it is competent or not, so long as it is fair. Don't do anything that will render the proceeding nugatory. Okay. So if we are going to take any step to go and monitor any primaries, now there's an injunction that stops us from going there. To go and monitor any Congress, there's an injunction that is stopping us from going there.